Our first panel this afternoon will cover multilateral tax cooperation. This panel will discuss the state of multilateral tax cooperation in light of the U.S. withdrawal from the UN negotiations on a framework convention and the proposals to retaliate against jurisdictions that implement the Pillar 2 rules agreed to within the G20 OECD inclusive framework. Is there a continued role for the OECD and the UN to play in international arenas if the United States does not participate? Might other institutions take their place? Where are we heading? Moderating this panel will be Michael Plougian, who is a principal in the International Tax Group of KPMG's Washington National Tax Practice. He serves as the International Tax Policy Lead within KPMG for the Americas and is on the KPMG Global Policy Leadership Team. Michael specializes in consulting and advising U.S. and foreign taxpayers on issues related to international tax, especially Pillar 2, the source of income rules, foreign tax credits, and U.S. taxation of international income. Prior to joining KPMG, Michael served as the Deputy Assistant Secretary for International Tax Affairs at the Treasury Department, where he was responsible for all aspects of U.S. international tax policy, including legislative proposals, regulatory guidance, bilateral treaties, and multilateral negotiations. He served as the top negotiator to the OECD on its two-pillar reform plan. Joining Michael on today's panel are Jesse Coleman, who's a principal in KPMG's Washington National Office, specializing in transfer pricing planning, compliance and controversy, and international tax policy. Prior to joining KPMG, Jesse headed the tax office at the private sector arm of the World Bank Group, where her responsibilities included analyzing and proposing solutions to tax-related risks in the World Bank projects, as well as developing and implementing OECD inclusive framework policies and procedures, and providing thought leadership on international tax policy matters. Prior to that, Jesse was a director economist and national partner with Baker & McKenzie. To Jesse's left is Professor David Shaviro. Daniel, sorry. Who is the Wayne Perry Professor of Taxation at NYU Law School, where he has taught since 1995. In 2003, he received the National Tax Association's Daniel M. Holland Medal, recognizing lifetime achievement in and outstanding contribution to public finance. Professor Shaviro's scholarly work primarily focuses on tax policy and other fiscal policy matters, and his books include Fixing U.S. International Taxation, Decoding the U.S. Corporate Tax, and Do Deficits Matter? At NYU School of Law, Professor Shaviro teaches various tax and other courses, including a scholarly colloquium on tax policy and public finance. To his left is Professor Renee Mariotti, who is the Hauser Global Professor of Law, visiting NYU this spring from his permanent appointment as a Professor of Law at the University of Zurich, where he holds the chair in Swiss, European, and International Tax Law. Professor Mariotti has actively contributed to the development of tax policy through his involvement on the steering committee of the Federal Tax Administration for Corporate Tax Reform and the working group of the Federal Tax Administration on the implementation of Globe Minimum Tax in Switzerland. His areas of expertise include tax controversy, dispute resolution, and tax arbitration in international tax matters, including transfer pricing and Globe Minimum Taxation. To his left is Professor Lillian Faulhaber, who is the Ralph D. Dwan Chair in Taxation and the Vice Dean of Georgetown University Law Center, where she teaches courses in federal income taxation, international taxation, EU tax, and digital taxation. Prior to joining the Georgetown Law faculty, Professor Faulhaber was an advisor to the Base Erosion and Profit Sharing Project at the OECD. She is a recipient of Georgetown Law's Frank F. Flegel's Excellence in Teaching Award and Georgetown Law's Member of the Year Award. Panel, thank you.
Okay, thanks very much. That's all the time we have for the panel. Thanks very much, everyone, for participating. I'm looking forward to a good discussion. So we're going to be talking about multilateral tax cooperation and where we are, what we're seeing from the U.S., where we might be going. Is there really anything for this panel to talk about anymore? We're also going to be doing, as Stephen mentioned, some audience polling. So I'm hoping that will help draw people into the conversation. I'm really interested to see what you all think about some of these topics. So I'm going to spend a couple of minutes just setting the table in terms of where we are with multilateral tax cooperation. So over the past 10 to 15 years, we have seen just an incredibly ambitious agenda on multilateral tax cooperation. So the BEPS project, Pillar 1, Pillar 2, the UN negotiating a framework convention on tax cooperation. And now we are seeing a backlash against that, especially in the US. Really, I would say around the world, there is a bit of a reaction against multilateralism generally. We are seeing the breakdown of some of the institutions, the post-World War II institutions that a lot of us have sort of taken for granted. But that the tax world is not immune from that. And so in the US, we have seen the US withdraw from the US negotiations on the Framework Convention. We've seen the White House memorandum repudiating any commitments made by the Biden administration in the context of the global tax negotiations, and requesting that the Secretary of the Treasury and US Trade Representative write a report on options that the US can use to respond to discriminatory and extraterritorial taxes. We understand that that report has been delivered to the White House. It has not yet been made public, but almost certainly it includes the UTPR under Pillar 2 and DSTs as discriminatory or extraterritorial taxes. It likely talks about Section 891, likely talks about tariffs as well. And we'll talk a little bit more about each of those as we get into this discussion. We have the apparent failure of Pillar 1, or at least it is in suspended animation based on the report of the co-chairs from the Inclusive Framework, as well as continued DSTs, Canada recently adopting or making live their DST. And we also have proposed legislation from House Republicans that has been co-sponsored by or signed onto by all House Republicans on the Ways and Means Committee to retaliate against extraterritorial or discriminatory taxes, at least including the UTPR and DSTs, likely sweeping in other taxes as well. And we'll talk a little bit more about that. So again, quite a backlash in the US against multilateral tax cooperation, or at least what has come out of multilateral tax cooperation in recent years. So with that, I want to turn to the first polling question. And that is multilateral tax cooperation in the interest of the United States? So I want to give people a chance to weigh in on that question.
We should take bets on how we think it'll come out. Just saying, we unfortunately haven't betted on how we think it's going to come out.
Great. Well, interesting. So the majority seem to be usually and sometimes. I think that probably reflects who this audience is, and the idea that in cross-border tax, having cooperation is a really important thing, especially to avoid double tax. I'm actually a little surprised that the last one does not get more than 6% at this stage in terms of, maybe this is just where I am in my life, but I always, think about the good old days. Multilateral tax cooperation used to be good, but now it's sort of lost its way. But I want to.
Different in the interest, though, or is it right?
Yeah.
Where we are now.
Yeah,
so
exactly.
Putting that out there.
That's a good point. So let's talk about some of these topics. And especially on that last point, in terms of whether it's been in the interest of the United States and whether that has changed over time. Maybe Dan, can you kick us off on the topic of why do we have multilateral tax cooperation in the first place?
Yeah, I kind of think of there being three reasons why you'd have multilateral tax cooperation. One is sort of very broad cooperation for objectives that it's hard to pursue alone. An example would be if countries don't like tax competition, they kind of have to cooperate to get rid of it or to mitigate it. Second is sort of more targeted or narrow reciprocity. And then the example of that would be like an actual policy of tariff remission if the other guy does it. FTCs, foreign tax credit used to be a more prominent part of our rules than they really are now. And FTC is kind of, I'll credit your taxes, you'll credit my taxes. It's kind of the way. Or another example would be like in treaties, we won't tax your residents on a source basis if you don't tax ours. So that's kind of a second reason, sort of targeted cooperation. The third reason is what I call two-level games. And that is when domestic players try to manipulate the international stage to strengthen their domestic position politically. When I say manipulate, that doesn't mean it's a terrible thing. I mean, a good example of it would be during the Biden administration, you had the Biden administration was kind of trying to play around in Europe to help assure that the EU would approve Pillar 2. Meanwhile, the congressional Republicans were trying to send signals to the EU, you shouldn't approve Pillar 2. So both of them are kind of trying to act in the international stage and cooperate with like-minded people abroad in order to get something that would help them domestically. When you have the current administration, it's clear it doesn't believe either in broad cooperation with other countries or in targeted reciprocity. It seems to have a more one-way unilateral demand. Also, two-level games don't really make sense when your aim is to abolish domestic politics. If there's an individual who rules by decree and policy is simply whatever that person says, there's kind of no need for two-level games because it just doesn't matter. You're not trying to build coalitions or anything like that. It's just politics consists solely of what does that person want to do today. So for all those reasons, I think there's been a collapse of reciprocity. The one other thing I'll just say, I'm sorry, I don't want to talk too long here, is obviously Pillar 1 and Pillar 2, there was a feeling that multilateral tax cooperation was being used in the world to make the U.S. Have to give way a little bit, which I personally at the time thought was reasonable given where things were, but that naturally made degraded support for multilateral tax cooperation in the U.S.
Yeah, and I think that those are interesting points. It does sound a little bit sinister with two-level games of bureaucrats going out and trying to get tax changes that they couldn't get domestically.
Both the Biden administration and the congressional Republicans were quite open about what they were doing.
Yeah.
And in both cases it made sense from their standpoint.
Right.
So,
Right. Lily, what's your perspective on that question?
Well, so I think when we look at multilateral tax cooperation from the perspective of the United States, one question is the multilateral tax cooperation happening regardless of whether or not the United States is involved? And so the United States has used multilateral tax cooperation in a variety of ways. If things are going on where the U.S. wouldn't otherwise want something occurring, but other countries are trying to move forward with it, engaging in the multilateral tax cooperation allows the United States to block it, right? You can see this in the Forum on Harmful Tax Competition, where the United States has come in and pushed back against various measures or limited various measures. So engaging for the part of the United States sometimes actually means constraining actions that the U.S. sees as less favorable. But the U.S. has also used multilateral tax cooperation to advance some of its ideas, right? So we've seen, GILTI, you can see that GILTI was initially proposed by the Obama administration. GILTI ended up actually existing in some of the BEPS outputs, and then it was picked up by the Trump administration. Then, as Dan pointed out, that story continued with the Biden administration using the Pillar 2 negotiations to try to push back against GILTI in the United States to sort of shape what it looked like. So the U.S. does often use multilateral tax cooperation to advance its agenda as well as blocking others' agenda, and also to work within the domestic agenda. So I think asking whether or not multilateral tax cooperation is beneficial to the United States, one thing is, if the U.S. isn't engaged in multilateral tax cooperation, it doesn't mean multilateral tax cooperation won't be happening without the United States. And so the U.S. has been making a choice up until now that engaging is actually more valuable, right? The U.S. is doing this because in its self-interest, the U.S. is actually able to get something from engaging in this.
Yeah, sort of better be at the table than on the table, right? Is that?
Well, actually, someone from the UK told me, he asked what our panel was on. I said multilateralism. He says, well, it's not dead. The U.S. just isn't at our table anymore. So I think, and that seems unfortunate to me.
Right. Well, actually, in that same vein, obviously, Renee, you have the burden of being the sole non-U.S. voice here. wanted to get your perspective on that question.
I mean, multilateralism is very important for Switzerland, not because we like all the BEPS measures. Of course, we are a country which is very much engaged in tax competition. Tax competition is a very important element to keep our country attractive for foreign investments. So this is the first point. But we also see without any multilateralism, we are going to, to be exposed to many unilateral measures, which might be totally different. We saw that with the digital service tax. We saw it with other regimes in the UK, in Australia, and so on. And so for the Swiss business, I think it's important to get some uniformity regarding the rules, even if the rules are not really, don't really match totally. For example, we totally recognize and acknowledge that the US sometimes needs to go another route. One example is FATCA. FATCA was a very important model, but nevertheless, we saw a kind of harmonization which is important to increase legal certainty. And this is an important key point here for Switzerland. This is the reason that we really are engaged in that, and we really hope that the US will stay at the table and discuss those matters.
Great. Thanks. So I want to get a little bit more concrete in terms of what we're talking about. Multilateral tax cooperation can mean a lot of different things to a lot of people, but traditionally that's sort of been at the OECD and at the UN. And wondering, Jesse, if you could sort of talk about what's been the role of the OECD and the UN in that process, and maybe thoughts on how that's evolved.
Yeah, sure, absolutely. And it's interesting, you say the OECD, and maybe because of my background, I think the inclusive framework, OECD. So, and I welcome you to kind of, correct me as you see it differently. But I mean, certainly from, a kind of a developing country perspective, the, inclusive framework, 140 plus countries sitting around the table, generating consensus, and, clearly developed Pillar 1, Pillar 2, along with all the other various BEPS action items. Developing countries were kind of invited to sit at that table. So it was the OECD, and then developing countries, were invited to essentially join the party. I mean, they would join the party as long as they adhered to the minimum standards, but join the party they did. But I think what we saw about a year ago, I would say, is, and I don't think it was new to a year ago, I think it's been kind of rumbling of many years, is that developing countries were looking at that table and unhappy with what was coming out. I think that they had thought that a lot of these BEPS measures and Pillar 2 and Pillar 1, that kind of there was more, they would get more of the state. And that just wasn't practically what had happened. So, the UN kind of creeps up, and the UN's not new to tax, right? I mean, they've been in the tax world for over a decade, right? They're like committee of so-called experts that they've been, developing their UN model treaty. They've been, developing the UN transfer pricing guidebook. So, I mean, they're not new to it, but, it's a different forum there where it's, a committee of what they call experts, which, members participate in their own personal capacity. So it just doesn't have any real oomph, we'll say, is that, they come forward and they say, we are not well served at the OECD. So we are going to create our own forum, and it's going to be at the UN. So it's interesting, though, they're not saying we just want it for developing countries. We want the whole world to sit at the UN because we think that's the spot that it should be in.
Right.
Clearly, the US disagreed because they're not sitting at that table anymore. But I mean, that process is still, it's going on, right? There is an inclusive framework like body that is being created over the next 2 years. And I think they are also, they have 2 protocols that they are also completing in the next 2 years. So they're looking at the taxation of services, cross-border services. They're looking also at kind of dispute resolution. And then somehow in that first bucket of services, they've also now said they're going to look at kind of the digital economy. Yeah. So they're looking at the same things. So now we've got another organization which, arguably everybody except the US is sitting at that table, right? The EU is still sitting at the table, but just not supporting anything at that table. So I think it's kind of an interesting spot of where we are right now.
Absolutely. No, I think that it's a great point that the U.S. has not withdrawn from the inclusive framework or the OECD. Like it's possible that it will, but that hasn't done that yet. But it has
Have you
withdrawn.
checked the news?
Yeah,
today?
exactly.
Or- I mean, no.
Didn't see this
you did
morning
not,
whether-
no.
Since the panel
Um,
started.
Yes, you're like someone's gonna raise their hand and be like, "Sorry,"
At 1:05 p.m. they did.
but no, I think
But it did withdraw from the UN process, and I think your point is well made that it's not like that process ended when the
But
U.S.
the U.S.
backed
wasn't
away
going to
from that, right?
support it anyway, right? So like they were, the benefit of them sitting at that table was to say no. I mean, nobody was listening. So I mean,
Exactly.
I just don't know if there was
Exactly.
if that really matters that much that they pulled out.
I think that's right, and I do think that is a big part of why they withdrew is that their voice wasn't going to make much of a difference in those discussions, given that it is a majority vote body, which is why the developing countries want the discussions to be there, right? Because they are numerically superior, and so they're going to get what they want in the UN, whereas in the OECD and inclusive framework, it's by consensus, and you can quibble about whether it's real consensus or whether it's countries being steamrolled, but it is by consensus, and so if a country objects, then that prevents something from happening. So it makes a big difference in
Well, they did,
the
like for
substance,
the last time around, right? They did say that substantive decisions would need to be done on a 2/3 basis. So that's still the
Yeah.
UN, that is.
Yeah.
But I mean, obviously speaking,
Right.
they have the numbers, right? So like 2/3 majority, they can do whatever. Developing countries have the ability to decide whatever they want right now.
Yep, exactly. And I do think that your point about Europe's position is really important as well. I think what comes out of the UN process, like the importance of it is going to depend a lot on what Europe and sort of non-developing countries do with that, and whether they sign on to it or
But I feel like they've
Otherwise.
given kind of indications with their votes about the creation of the framework in itself that they are not supportive, right? Whether they're abstaining or they're saying no, I think that's the same thing. I always think that's it's like splitting hairs, is what I think, Michael.
interesting. Well, okay.
Sorry,
We'll see.
that was
We
a
will
strong
see.
statement.
No, and a lot can change in 3 years. But I do want to. I think we should move on to the next polling question. And the way these polling questions work is we are trying to preview what we're going to talk about and get your thoughts before we discuss them. So, how will Europe and the rest of the world respond to U.S. threats about Pillar 2/DSTs/other measures like VAT? All right.
Makes me feel better, right? that
yeah.
We're not going to be in a trade war. Sorry.
It's a pretty optimistic crowd. I like it. It's good. Yeah, exactly. So do you want to give a little bit more context in terms of the U.S. threats on these measures? So obviously there are the White House memoranda and EOs on tariffs as a potential retaliatory measure against DSTs specifically. There was the White House memorandum I spoke about at the top, which was more broader in terms of DSTs and probably the UTPR and the potential for the invocation of Section 891, which would double the rate of U.S. tax on U.S. income of individuals and corporations from countries that have the offending taxes. There is the Smith Bill, the Defending American Jobs and Investment Act, which would, I basically think of it like a modernization of Section 891. Instead of doubling the rate, it would incrementally increase the U.S. rate on individuals and corporations from jurisdictions with an offending tax by 5 percentage points per year, up to 20 percentage points of increased tax. I'm not going to get into the details of that bill or the Estes bill, which I'll talk about in a second. Obviously, we could do an entire panel on those bills. But I do think it's important to recognize that they have been signed onto by all Republican members of the House Ways and Means Committee. It seems very likely that one or both retaliatory measure will be included in the House version of a reconciliation bill as a revenue raiser and as a way to push back against what we've seen from the inclusive framework under Pillar 2, as well as DSTs. The Estes bill, the Unfair Tax Prevention Act, would basically transform BEAT into Super BEAT, which just for foreign parented multinationals, it would get rid of the thresholds for BEAT. It would get rid of the SCM exception. It would treat 50% of COGS as a base erosion payment. So very draconian sort of measures being contemplated by Congress as well as the administration here. So there's been a little bit of confusion about what is the U.S. position on Pillar 2. I think we still don't know officially what the U.S. position is. They have not withdrawn from the negotiations. They sent a delegation of 4 people to the Inclusive Framework Plenary this week in South Africa. I don't think that the position is we're done with this, we're pulling out. I don't think it takes 4 people to say that, but we don't know exactly what they are asking for. There's 3 main asks that we hear about publicly. One is to turn off the UTPR, possibly across the board, possibly with respect to profits in the U.S. Second ask is treat existing GILTI like a good IIR, or alternatively turn off the UTPR with respect to foreign subs of U.S. shareholders. The third one is change the rule order on QDMTTs versus GILTI. So have GILTI come before the QDMTT, a tax on profits booked in that jurisdiction. So pretty significant asks, and I think the big question at this point is there a path to a compromise solution, like we just asked about in that question? So I wonder, Renee, if you could speak a little bit to your views on that.
I can speak from a Swiss perspective,
Sure. Yeah,
of course. I think these are interesting proposals, and I don't believe anymore that we can keep on with Pillar 2. We need to modify Pillar 2. One point that you raised is obvious. UTPR needs to be repealed, in my view, because of many reasons. Actually, I don't think that the US will accept the UTPR. The retaliatory measures that you mentioned are really dramatic, and I don't think that the Europe and other OECD members which have adopted Pillar 2 will actually really want to start a tax war with the United States. What is the Swiss perspective? We anticipated that, actually, and this was the reason that Switzerland didn't implement the UTPR, because we noticed that this might become very, very problematic. This is one point. What's about GILTI equivalency? I'm very skeptical. I don't like that, actually, because it will disadvantage European and Swiss multinationals. GILTI is more flexible based on the global blending that they actually use. And so I think we have to go the other way around. We need to modify the GloBE top-up taxes in a way to move towards global blending. I think this would be extremely helpful. At least we could say all multinationals pay their fair tax. This is the key message that I think politicians want to sell. And then there's another aspect about tax competition. So when they designed Pillar 2, they wanted to target 2 or at least achieve 2 goals. The first goal was to increase taxes for multinationals, and the other one was to curb tax competition. So maybe this second part of the goals of the top-up tax maybe needs to be given up, and the European Union has other tools. We know them. State aid rules that they can use to make sure that they can keep the level playing field in Europe. So this is the second point. And then another one was the extension of the UTPR safe harbor. I think this is also very problematic. Of course, if you start doing something like that, every country will increase the tax rate, and then everything will go on, and you don't have the entire system doesn't really make sense anymore. So I'm very skeptical. I think we need to repeal UTPR, and I fully agree with you with respect to the rule order. This was a big mistake, actually, with the rule order. Switzerland, for example, has to raise QDMTTs. Also, they don't want that tax, and the US has to loses tax revenue because they have to give a credit. It doesn't make sense at all for me.
So it sounds like there's a path forward on the QDMTT point. I think that it's a hopeful note. So I want to take a little bit of a step back on this question and ask a little bit broader question in terms of are these demands sort of consistent with traditional U.S. exceptionalism of kind of going its own way, but largely still engaging in the multilateral project, or is it more of a repudiation of multilateralism? Lily, what do you think about that?
I mean, when you're at the OECD and you're talking to people from other countries and you are an American, even if you're not representing the United States, everybody is very aware that the United States has gone its own way at various points in history, right? People have a long memory of CFC rules and how CFC rules were unilateral measures and then other countries end up following. People remember FERPTA and don't necessarily, remember necessarily that then we ended up with country-by-country reporting. So there have been, I do think that the story of international tax is a story of rising and falling unilateralism and multilateralism, right? When there is unilateralism until it turns out that we're talking about cross-border transactions, we're talking about an international economic regime where you have multiple jurisdictions and you're going to have some sort of cooperation. And so is it unprecedented that the United States has gone its own way? I wouldn't say it's unprecedented that the United States has done its own thing. Remember in 2016 when there was the Apple state aid case, that's when we all learned about 891 because somebody suggested that we start using that, right? And so the president didn't himself end up suggesting it, but there have been times when the reaction of the United States is to focus more on being more unilateral. That said, this is part and parcel of a whole host of more aggressive, more threatening responses, more unilateral responses. So if we were just in this room only talking about Pillar 1 and Pillar 2, I actually think, a lot of people were critical of how the United States negotiated Pillar 1 and Pillar 2 against the interests of the United States, arguably, right? And so maybe not everybody would agree that this was the wrong thing for the US to do. But we're also talking in the context of tariffs. We're talking in the context of everything else that's going on at the same time in trade and in the economic space. And so that it feels unprecedented because of what it's part of, I would argue, as opposed to necessarily pushing back just against sort of parts of Pillar 2 or Pillar 1 we haven't even talked about, but not moving forward with Pillar 1. Those in and of themselves maybe don't feel as unprecedented as being part of the whole discussion.
Right. And when you say part of the whole discussion, it sounded to me, and I just wanted to confirm this, that it's not just the U.S. Sort of pushing back on multilateralism. Like lots of countries have been sort of rejecting the existing international tax framework, right? With DSTs and DPTs and,
Yeah.
and all that kind of stuff. Is
Yeah,
that
so I mean, if you look at what, and Renee started to hint at this, if you look at why we're even talking about Pillar 1 and Pillar 2, right? What were the supposed reasons for Pillar 1 and Pillar 2? Well, Pillar 1, there was a criticism about transfer pricing, right? We haven't really talked about Amount A and Amount B, but there was a criticism that there needed to be some fixes to transfer pricing, and that our international tax system allowed large, primarily tech companies to pay very low rates of tax and not pay taxes at all to the jurisdictions where they were actually doing a lot of business, even if they weren't located. And for Pillar 2, the argument was that we hadn't been able to combat tax competition, and that there needed to be some way of ensuring that corporations were actually paying some minimum amount of taxation. So the reason that we had these was because there was a sense that the international tax system as it existed wasn't able to address those concerns. And so one way of responding to that was Pillar 1 and Pillar 2. The reason a lot of countries went to the table for Pillar 1 and Pillar 2 was because the other options were unilateral measures that they were seeing as threatening. So the UK came out with the diverted profits tax. Australia came out with the multinational anti-avoidance law. You had Germany in Section 49. You had all of these unilateral measures, and countries felt that they were all signs that something had broken in the international tax regime. And so they decided to come to Pillar 1 and Pillar 2. But there was this overall sense that something wasn't working, and that you either had to have a unilateral response, but that wasn't sufficient, so you had to go to a multilateral response. And now we're kind of back saying, do we actually want to be fighting it in a different way?
No, Dan and Jesse, you want to?
I'd have to agree with Lily that if you look just at Pillar 1 and Pillar 2 so far, it might not look that unusual. And just, by the way, to extend the times the U.S. has gone unilateral, none of us remember this because it happened more than 100 years. I mean, none of us remember it from personal experience because it happened more than 100 years ago. But we adopted foreign tax credits. That was done unilaterally. And another thing I think of is FATCA was sort of turned multilateral because everyone liked it. But at the time it happened, I think it was subjectively, we're just going to do this. We don't care what anyone else thinks. We're going to bloody well bludgeon the banks. So it's funny, the U.S. tried to be unilateral, but then it turned out other countries liked it too. Also, I think, again, and this is also agreeing with Lily, Pillar 1 and Pillar 2, there was not surprising that in the U.S. there'd be some real pushback about it, because I remember attending conferences where people would say that the U.S. is the meal. We're on the banquet table. Someone like Mindy Hirschfeld writing tax notes, this is not good for the U.S., focused on, we'll lose relative to where we were before from this. People who think it is in the U.S. national interest were really thinking more about keeping alliances, working well with people, being reasonable, things like that, sort of more long-term agenda. So anyway, and again, so seeing, Pillar 1 wouldn't be flying great in the U.S. even if it was doing well elsewhere, and all the questions about how hard they're going to hit back on Pillar 2. But it is the broader stuff that's going on. I mean, again, we don't really know how wild and crazy this administration will end up being yet. But you have like the tariffs going like this every day. And again, I feel like I need to check my phone in case things are put back on again. And you have just the other things that are going on in the U.S., like people being sent to El Salvador, talk of, we all know, without dwelling on it here, that there are some signs that this is going to be a unique experience in the history of the United States, and that you shouldn't really sane-wash it. Try to believe it makes more sense than it does. Again, we don't really know how it's going to play out, if the relative adults will scrape through or not, but there's a possibility that something very unique is happening here, and not in a good way.
And so I think I have to be the optimist here to your pessimism. I hear you. There are crazy things that are happening, but I think this kind of pull towards unilateral, multilateral, goes back and forth. I just think, yes, there's a lot more craziness right now than there has ever been before, but I don't think that means we can't pull back to a more multilateral, rational place to be. I mean, it might take 3 years and 9 months, but I just think that...
You think the third term will be better?
Ow. I just think we just can't think that this is dead. And I think I just personally think too, even if the U.S. if the U.S. even pulls out of their spot, I think there'll still be a spot for them later. Yeah. And again, I feel like I have to be optimistic though, or the other the other alternative is, I can't go there with the third term here.
All right, that's actually, I think, a good segue into our third polling question, which is, where does multilateral tax cooperation go from here? This is really interesting.
Huh.
Yeah, and I think we want to do a little bit of a debate on this this topic, but as a 20% saying it's dead, that's
Low,
something.
yeah.
Optimism didn't carry the day, right, for those 20%.
Apparently, you cleaned our clock.
Um, so we've talked about the pushback against the OECD, and also the pushback against the UN by the US and by European countries, and wanted to explore, sort of alluded to by this question, are there other options for multilateral tax cooperation, other international organizations, regional organizations? Jesse, can you talk through some of that for us?
Sure. Well, I think we talked about the UN, right? So we can kind of put that to
Yep,
bed.
yep.
I mean, there are kind of other organizations in the space. None of them write laws, though, right? I worked at the World Bank Group. They write no laws in
Right.
and of itself.
Neither does the OECD.
Well, yes, that's fair, but but nor do they write, guidelines that become laws. That's just not their role. Nor the IMF, right?
Right.
They're also in the space, but not really in the space. We do see, regional bodies though, which I think have been somewhat successful. I mean, really, the European Union and Commission, the most successful of the bunch. You do see kind of other, on the developing country side, right? You see ATAF trying to kind of be a regional body. You see there's a kind of a Central and South American body that just started that they're trying to kind of gain some momentum. There's the G24, so the group of more than 24 countries. I don't understand the name, but there's a bunch of developing countries that all come together that try to kind of tell countries how they should vote on policy. So I mean, they do exist. I actually, with the exception of, I would say, the EU, I just don't see any of them as being kind of a body that kind of can withstand not withstand the test of time, but actually create change, right, or push change. I mean, I think where we are, I mean, the OECD the inclusive framework was doing a decent job. I mean, if you look at kind of where everybody is, it was interesting though that and you had raised this too, Michael, and I think Renee as well in our prep session. Maybe it should be not the inclusive framework. Maybe it's time for the OECD to go back to doing the OECD, which I struggled with when we talked about that, simply because if we have the OECD that's going to set, global policy, it doesn't seem fair to me that we don't let everybody sit at the table with them and at least talk about what that policy is. So I don't know if there is another good alternative out there.
Right. So it is interesting on the OECD as the OECD versus the inclusive framework, and definitely take your point that if the OECD is setting global standards, like, shouldn't everybody be at the table? I do wonder though, because the OECD member states, as the OECD member states, their share of global GDP has declined dramatically over the past couple of decades, and it's not clear whether the OECD can or should set global standards, but they may be able to agree on things that, at least among themselves, could avoid double tax, could help smooth some of the things that we're seeing. So I do think it's an interesting sort of debate in the OECD itself as to what is the right path forward. And they're having this not even just in tax, but the OECD as a whole is having this debate internally about should the inclusive framework be the model for the other policy areas that the OECD deals with as well. And so I think that there's disagreement about that. But Renee, I want to draw you into this conversation as well in terms of what you see as potential options for multilateral tax cooperation going forward, and maybe even also this OECD versus inclusive framework debate.
It's really a very challenging question, because now we are in a situation where we have the UN framework tax convention, which is negotiated, and where the developing countries can much more say. They can also set the agenda, which is not possible to the same extent at the inclusive framework, which is very much actually guided by the G7 and the G20. I think this is the most important issue we have right now. So they have now another forum that they can use, and we still don't know how they will interact with each other. And maybe they are going to undermine the work of the inclusive framework. We don't know that. It's clear the inclusive framework actually failed because the developing countries didn't get the taxing rights that they wanted to get, actually. This is the reason that they are not so much in favor of amount A. They want to have much more. And this is the reason that they also include the digital economy now into the first protocol. And so I think at this point of time, it's really difficult to anticipate what happens. But I do think that the OECD should focus on their traditional work. This means to develop the tax treaties further. There will be new questions coming up about mobility and so on. This should be one important focus to keep on working on the tax treaties on the one hand. And on the other hand, they maybe should give up these projects like Pillar 2, where they really interfere into the tax sovereignty. This is the first time that the OECD inclusive framework created a model legislation with respect to substantive tax provisions with a huge impact. And this really goes to the heart of tax sovereignty, and I think they should abstain from such projects. And this is might be the reason that we ended up now into this discussion.
Yeah, no, so it's interesting you raised, this is the first time that the OECD or inclusive framework has gone into domestic legislation. The BEPS project did also have some domestic legislation, particularly in the anti-hybrid space, which has been very influential. But I do think there are differences between Pillar 2 and anti-hybrids, right?
Well, I was also saying, I guess there's a difference, right? Transfer pricing rules, right? The OECD guidelines are kind of widely recognized, but they're just guidelines, right? It's not domestic, because I was thinking the same thing. I was like, oh, that is different, right? Because everybody interprets the guidelines slightly differently. But I don't know, from my transfer pricing hat, I think it's actually really helpful if we have everybody kind of have the same guidelines, right, about how the arm's length standard is understood. So completely separate though from multilateralism. Sorry.
No, it's I think that's a great point that in order to coordinate on this, to some extent, you do have to have an impact on domestic law, because that is going to impact how cross-border transactions are taxed.
I will say, if I can just chime in,
Yeah.
I think, the last 12 years have been a story of the OECD prevailing in an interinstitutional competition. So when you said the World Bank Group they don't write law. Well, 12 years ago, the OECD didn't write law either. And there was a competition over what organization the G20 would pick to do this BEPS work. And there were multiple options out there. The OECD prevailed for a variety of reasons, but in BEPS 1.0, it wasn't just the OECD, right? It was the OECD plus the G20 countries, so it had already started expanding. And I do think it's it's worth noting that the institution is very, very different than it was when it was chosen. It's welcoming others to the table, but it also has a lot more clout than it did on the international stage in this space in terms of what it does. And so it's worth, it's just worth noting that the institution itself has an interest in playing this role. This is true for all institutions, right? And it is worth noting that when you're thinking about, well, who is going to take this role? The OECD is well suited because it was chosen 12 years ago, but had another institution been chosen 12 years ago, things could look very different, and they could actually be differently suited, but well suited at this moment for something else.
I think it's a great point, and I wanna ask a little bit about the first choice that the 20% chose, right? That multilateral tax cooperation is dead. What if it is dead, right? What happens? What are we gonna see? Are we gonna see a lot of DSTs, unilateral measures, tariffs? What? And everybody should please feel free to jump in here.
I do think we're going to see a lot of DSTs. There's sort of an economic question of whether the DST is actually borne by the company or by domestic consumers, and there are kind of credentialed economists on both sides of that debate. It would be kind of good to know the answer to that. But they politically make sense, and I don't really see how the U.S. can bully people out of it, both because the whole thing has become so much of a who is going to back down thing, but also because there are all these other things the U.S. is doing anyway. I was reminded of the line from Animal House when they're going to, should they don't have a toga party, it's a bad idea. And the guy responds, I've got news for you, pal. They're going to nail us no matter what, so we might as well have some fun. That's kind of how I think the countries are going to think about the DSTs. It's not like if we don't do the DSTs, the U.S. is going to be nice to us. So.
But I think I fully agree. I think, if multilateralism is dead, we're stuck with DSDs and tariffs and trade wars and a little bit of what we're at right now, but we're not quite there yet. I still am optimistic though, Michael.
Maybe I'm more optimistic
Okay,
in this regard. I don't think that at least the European Union will introduce the DST directive. There's already a proposal. They actually hammered out a proposal in 2018. They stopped it because of the negotiations on the Pillar 1 and Pillar 2 project. And if you look at the retaliatory measures that are actually announced or that are threatened, I don't believe that the European Union wants to start a tax war with the United States, as I already said at the beginning. But I see actually another way here. We have a gap in the application of the VAT code, and there are already investigations going on. And I think member states will start closing this gap and applying the VAT code on the digital companies or internet companies to raise money. And the only question here is how to measure the remuneration that would become taxable under VAT code. There is really a broad consensus that actually VAT needs to be applied to such digital services. The question is just how to measure the tax base.
Is that for like the barter transaction theory?
Yeah, absolutely. This is exactly this theory. Yes.
Great.
So I'll just go back to what I said earlier, which is that I feel as if there's always a back and forth between unilateral and multilateral. And so if multilateral tax cooperation is dead right now, I still think there's going to have to be some sort of multilateral tax cooperation. It might look different, it might be somewhere else, it might take a while to get to that, but every time that countries try to revert back and be purely unilateral, they realize that they have to look to others to make this actually work. And so maybe there will end up being an entire multilateral tax convention on DSTs, and all of us will harmonize our DSTs, and that's where we'll be in 5 to 10 years, right? But that might not be where we want to be, but I actually think it's very hard every time countries try to go it alone, they realize that that's actually not in their best interest. And so I don't know if that's optimistic or not optimistic, but I do feel like
I thought that seemed very optimistic.
Yeah.
I feel like you've joined me here.
Congratulations, right? You've convinced me.
Great. Well, I wanted to open it up for questions from the audience in terms of where we are, where people think we're going. I would actually note that we have seen over the past couple of months India repeal both of its equalization levies, its equivalent to DSTs. And my understanding is that is based on India's desire for a free trade agreement with the U.S. And those negotiations being done bilaterally through the USTR. We have also seen, which surprised me to some extent, the UK government making some statements that maybe we could modify or repeal our DST. I think for exactly the same reason as India, they're very interested in having a free trade agreement with the U.S. So we do see some movement on DSTs in a bilateral context here as well. To note that. Any questions from the audience?
Hi, thank you. Insightful comments from everyone. Len Lipton, Globe Tax Services. I was curious of the panel's views on whether some of this may intercede on withholding tax around royalties, interest, dividend payments, and so forth, which have not yet really entered the tariff conversations, but the EU with FASTR is certainly moving in that direction. The OECD has led that historically. Appreciate comments.
Well, so I guess I would come at it in a couple of different ways. Maybe one is we are seeing at least in terms of rhetoric, right, greater emphasis on source country taxation, withholding. Certainly in the UN, there is a push for greater withholding taxes, including on services in the digital economy. The Smith bill, right, the Defending American Jobs and Investment Act, would actually increase U.S. withholding on outbound payments from the U.S. So I do think there is the possibility that we see greater withholding tax over time in this context.
I mean, that certainly is the developing countries. Like they just had the kind of expert tax committee meeting 2 weeks ago, and they did kind of introduce the article. It's like 12AA that would allow, like, for the UN model treaty, right, which is not the one that the U.S. would use, that would kind of allow for greater withholding. So I think that is certainly on their agenda. Which I think that also kind of just means, it's interesting, it's part of the treaty, right? The U.S. isn't going to sign any of these treaties, but the real concern becomes, do countries put it in their domestic law, right? So what comes out of the UN, how does that navigate into domestic law, which is, I think, the real concern.
Yeah. Just to put maybe an exclamation point on that point, is that regardless of what the U.S. does, right, the U.S. doesn't have bilateral treaties with a lot of developing countries. And so to your point, the real question is, what do they put in their domestic law? Because U.S. multinationals will be exposed to that because we don't have treaty protection in a lot of cases.
Because it used to be historically, right, like nobody would adopt the UN treaty, but and that's how they but if they can actually kind of if they can get a consensus to put in domestic law, that changes the dynamics completely.
All right. Well, with that, I want to thank the panelists for this good discussion.
All right, thanks everyone. And we're getting ready now for our last panel discussion today, regulatory disruption, when we will delve into the Supreme Court's Loper-Bright decision, which significantly curtails the power of federal agencies to interpret the laws they administer. This ruling could lead to increased taxpayer challenges to regulations, and then of course conflicting court decisions. Additionally, we had the February 19th executive order to rescind regulations that are not based on the best reading of statutory authority, which adds, of course, another layer of complexity. So we're left asking the question of what now? Moderating this panel today is my friend Danielle Rolfs, who asked me not to reintroduce herself. So I'll just thank you for all of your support for this symposium. I really appreciate it, and I'm so lucky to get to practice with you.
And I'm sorry for providing so many feedback on all of the little details of the program. I keep saying things
Very
with Britt
appreciated.
nearby, and then she gets defensive, and I go, "Oh, I didn't mean that like a criticism. I'm just
Oh gosh,
constantly making
Danielle,
observations."
private moments. Okay, moving on. All right. Joining Danielle is Michael Desmond, who has extensive experience in all things tax matters, but particularly focusing on administrative tax policy. He's a partner at Miller & Chevalier, and prior to joining Miller, he served as the 48th Chief Counsel of the IRS, overseeing the interpretation and enforcement of federal tax laws, and as tax legislative counsel at the Treasury, where he advised on domestic tax policy. To his left is Professor Kristen Hickman, who is a renowned expert in tax administration, administrative law, and statutory interpretation, with articles published in top law journals and citations in U.S. Supreme Court opinions. She served as special advisor to the administrator of the Office of Information and Regulatory Affairs and is a senior fellow for the Administrative Conference of the United States. She currently is the Associate Dean for Research and Intellectual Life and the McKnight Presidential Professor at the Law University of Minnesota Law School. And then to her left is Michael Schleyer, who is a highly respected tax lawyer and a retired partner from the New York City law firm of Cravath. He's a past chair of the New York State Bar Association tax section and continues to serve on its executive committee. Additionally, he chairs the New York Tax Forum and is a past president and current trustee of the American Tax Policy Institute. Danielle, I'll leave it to you.
Well, thank you, Britt. And I think we're going to try on this panel to unpack the Loper Bright decision. Was it a nothing burger? The sky falling? To put it into the broader context of our tax regulations and tax exceptionalism, and to consider the ultimate question of what Loper Bright means for tax collections in the United States, and as Congress considers a tax bill, what it means for Congress in writing legislation. So with that, I guess we move to what we're calling the pre-test. I don't actually think we have a post-test built in, but we wanted to ask the audience, do you think the Loper Bright decision to overturn Chevron was correct? And maybe as folks answer that question, true. I'm looking for Professor Shaviro. I think he went into the overflow room to start a toga party.
It's shifting.
It's a little cold in here for a toga party. That was another comment, Britt. Where's Britt?
She's ordering togas.
Okay, well, we look pretty split, actually. So maybe now having asked everybody how much they like the Loper decision, I'm going to turn it to Mike to help us unpack the decision. What really changed in terms of Supreme Court precedent?
Sure. So I think we'll take just a couple of minutes to set the stage. This is probably familiar to most folks in the audience here. But just to talk about Chevron, the history of Chevron, and then we could talk about what did or did not change. My own personal editorial on the nothing burger comment is that at a minimum, the Loper Bright decision will be yet the latest full employment act for lawyers, in particular tax controversy lawyers.
That
So
is
from
clear.
my own personal and professional perspective, it is not a nothing burger. Whether we look back 20 years from now and see that the law actually changed or that an additional dollar was collected in taxes, I think is an open question. I'm more skeptical of that point. But dollars will be collected on the taxes on income made by tax controversy lawyers who are going to be litigating Loper Bright. So in that regard, it's not a nothing burger. But to go back just briefly and set the stage. So Chevron was decided in 1984. It's got some interesting historical elements to it. And I'm always corrected on this, but I think it was Justice Gorsuch's mother, right? That was the head of the EPA back at the end of the Carter and in the beginning of the, I guess, Reagan administration. And so the Chevron decision itself actually involved a regulation that was industry favorable. It was letting up on some regulation that had been implemented in the Carter administration. So we always kind of look at Chevron as this like deference to the agency's ability to regulate and impose regulations, but it actually arose out of a industry favorable change in regulations in the Reagan administration. Again, when Gorsuch's mother was the head of the EPA and the agency that issued the regulation. But in any event, those are just sort of historical points. The three elements of Chevron that had been with us from 1984 until 2024 were just the gating question of, is a regulation something that is been or has been promulgated within an agency's discretion, or authority, I should say. Does a law give it the ability to act in this area? And does it have the force of law? So is it something that has an impact on regulated entities? So that's step 0, and there are other elements of that as well in terms of the regulatory validity. Did the regulating agency go through the right steps to actually promulgate the regulations? Some sort of gating questions that are background in a lot of cases and important questions. But the real key points that we'll talk about today, because the change with Loper-Bright comes in step 2. So you get to step 0, kind of administrative authority to issue, or statutory authority to issue this. And then step 1 is there anything ambiguous about the statute that opens the door for the agency to interpret an ambiguous statute? And if not, then the inquiry ends. If the statute is plain on its face, no ability to regulate. But most of the work comes in Chevron under step 2, which is an ambiguous statute. And then did the agency act within its discretion to interpret that statute? And Chevron gave a fairly broad degree of discretion to an agency and essentially said any reasonable interpretation of the statute in a regulation will be sustained. And the court may have disagreed with that being the right interpretation, but if it's within a range of reasonable interpretations, then under Chevron step 2, the regulation would be upheld. So that was the framework that we have under Chevron. And then just briefly, so the kind of gating question doesn't really change. Does the agency have the ability to issue regulations? Is there a statute that authorizes this? Kind of the procedural validity, did you go through the right notice and comment process? That's all the same. And then step 1 and step 2 change then with Loper-Bright. So now Loper-Bright, instead of giving this degree of discretion to an agency to promulgate any reasonable interpretation, the court has said that it's got to be the best interpretation. There's only one interpretation of a statute. There isn't a range of interpretations. And it is the court's role to find the best interpretation and the only interpretation of the statute. And it may well be the interpretation that is in the regulation, but there's no bias toward the regulating agency that says that they get to choose within a range of reasonable interpretations. If their interpretation is going to be sustained, it has to be the best interpretation. The court has to agree with that. So that's the real change, is it, at least the perception is, it will narrow the range of permissible interpretations that an agency can come up with, and that is the change with Chevron. We'll come back and talk a little bit more about the practical consequences, I think, from having sat in the role of a regulator. The IRS, if you ask them, is always coming up with the best interpretation of the statute. So a lot of the government kind of take on it is this isn't going to change much because we always have the best interpretation of the statute. I know even internally that's not always the case, and you realize you may not have the best interpretation, but it's a good interpretation, and so under Chevron that was good enough. That won't be going forward, at least under the Loper-Bright standard. So very quick walk through the park on Chevron and Loper-Bright.
Well, I'm going to ask you, I have on the screen here the Supreme Court's language around stare decisis.
Yes.
They said, we're not going to upset any of the old cases. Now, very few tax regs had actually made it to the Supreme Court to be considered under the Chevron standard. But so how significant is this language? How much do we need to worry about old regs?
Well, I think we do need to worry about old regs, and I think this was to put a marker down and not invite every regulation that's been promulgated since 1984 to come back in for review. But as a practical matter, as I started with, I think any controversy lawyer is going to look at every regulation, is going to want to re-litigate it. And we've seen that just in the year that the Loper-Bright decision has been out. I just looked briefly this morning. There are about 30 opinions in the tax area that cite Loper-Bright. And even within those cases and beyond that, there are about 30 orders out of the tax court involving motions for reconsideration of prior decisions that involve the validity of a regulation under Chevron. So even though the court says stare decisis, there are certainly litigants out there saying, I want to re-question this, I want to file a motion for reconsideration, we've got a new standard out there. So for the most part, I think courts are looking at prior decisions under the Chevron doctrine and either upholding or they would have invalidated a regulation under either standard. So I'm not sure it has changed much, but it is something being litigated very actively. And I think will be for the foreseeable future.
Let me ask about that. I mean, suppose some circuit, make up the First Circuit, doesn't matter, upheld some regulation under Chevron, meaning it was a reasonable interpretation. Maybe they thought it wasn't the best interpretation, but it was reasonable. now you get some other circuit who never was bound by the First Circuit in the first place, and they're certainly not going to be bound by, they won't even want to be bound by, if the First Circuit didn't even follow the same standard that the new circuit would be following. So they'll ignore it completely and apply the best standard, the best interpretation, I would think. So they'll go their own way, giving no credit at all to the First Circuit, which used a different standard. So it's sort of guarantee, and the First Circuit may have also thought it wasn't the best interpretation, but it was a reasonable one. So everybody may think the best interpretation is X, but Y was reasonable. The First Circuit followed Y. Everybody else will follow X because they're forced to follow the best interpretation. So it sort of guarantees almost the circuit split, which means years is going to go by. The Supreme Court isn't, it has Loper-Bright for the entire federal code. Tax is just a tiny part of it. They're not going to be deciding all these circuit splits, and the same issue is going to come up all over.
Right.
So the whole country is going to have these circuit splits in every possible portion of the U.S. code. And then in tax, what it means is that people. Most circuits won't even have decided these cases. The people in the other circuits, they can either follow the regulation if they want to, if that's better for them, or they'll decide it's invalid based on some other circuit. So then have everybody following whichever position they want. And so that's where the revenue loss is going to occur, I think, not just the lawyers making money.
I will make the observation, though, and this is at least somewhat useful, I think, that even though, we had circuit splits before, you're right that I think under Loper-Bright we're going to have more circuit splits. But one virtue that tax has, at least with respect to some tax regs, is if a circuit split develops, because most tax cases go through the tax court, if the tax court on more than one occasion has said, we see that there's a circuit split here, we're going to pick a side, and then, or they side with, they just did this on the State Farm issue with respect to the conservation easement regs.
Right.
So if the tax court then comes in and says, well, we're going to interpret it, we're going to invalidate the reg
Well, wait, they'll pick a
in
side.
order to avoid the circuit split.
No, but they'll pick a side if the taxpayer goes to a different circuit that hasn't decided the case. They're bound by the circuit.
No,
to
I
which
get
the
that,
taxpayer
but
goes.
sometimes the tax court will resolve a circuit split in a certain sense by invalidating a reg, and in order to get rid of the tax, or in order to get rid of the circuit split.
I don't think they can do that. Now, you're the expert,
no,
but I think they're bound by the circuit to which that
Yeah.
particular
That's
taxpayer would
correct.
appeal.
But
Well,
then-
okay, that's
Yeah,
that's
then there are a
fair.
dozen other circuits that they can set the law for.
They could set the law for the
National
other
basis.
circuits, and oftentimes then I've seen Treasury, or sometimes I've seen Treasury then revoke a reg rather than leave a circuit split out
Yeah.
there in light of the tax court's effort to resolve the issue in all the circuits in which it hasn't been decided by invalidating the reg. You can debate whether that's a good approach or a bad one, but at the same time, that's at least somewhat unique to tax relative to other administrative
You've
areas.
got a court of national jurisdiction.
Yeah.
I would go back just to, Mike, I think I agree. You're reiterating my point that this is going to be fodder for litigation, but there also probably, as a practical matter, not a whole lot of decisions that were decided under Chevron where the court says this isn't the best interpretation, but it's a reasonable one. They just
They
sort
don't
of,
get to that. They just
They don't
say
get
we
to
don't
that,
have to
right.
decide the best interpretation.
right.
It's reasonable.
that's right. But that gives some room to come
Yeah.
back later and say, all right, we upheld the regulation before,
Yeah.
and it may have been under Chevron. In the back of my mind, it may have been a reasonable interpretation, but we're going to come back now and say that it's the best interpretation. Same answer.
Yeah, it's sort of forced to do that today.
Right,
Yeah.
right. But it gives them it gives the
Yeah.
court an easy out there
Yeah.
to say this
Yeah.
is still the best interpretation. It was before a reasonable interpretation, so we have the same
Yeah,
outcome.
but you still get splits.
Sure.
Yeah, just to distill what I think I heard is I think there's very little significance to the Supreme Court's reference to stare
Yeah,
decisis for
right.
tax regs. Very few tax regs have had their validity considered in a court.
And
And
certainly
if-
not by the Supreme Court, which is all it really applies to, right?
And we have the ability, as illustrated by this conversation, to often pick a court. We're able to choose. We didn't even mention the Court of Claims. Pick Court of Claims, tax court, district court. If your reg has been considered in one of those venues, you can choose a different one. So I think it has very little significance for tax regulations, and we're going to see these questions come up for lots of old regs. And in fact, we do. That's what we have on the screen here is a number of the cases that we sort of cherry picked. You mentioned there are maybe 30 under consideration. Do any of these jump out to you as worthy of comment, Mike?
Yeah, I think others may have comments as well, but just a couple of them to get started. The Obdo case is not a Loper-Bright decision. It was actually the last decision one of the last decisions from the tax court under the old Chevron standard. So I put it in there for that reason. But it's also important to note because a lot of the outcome in these cases, and we see some recent cases that we'll talk about, the Varian case, which is referenced next, which is even under a Chevron standard, that court would have been rendered invalid. So it's a lot of Chevron step 2, where the court says this is not a proper interpretation of the statute. We never get to whether it's a reasonable interpretation. The statute is clear. The effective date in Varian is what it is in the statute. You can't change that by regulations. So the outcome in a lot of these cases is going to be the same under either Chevron or Loper-Bright. And I think the Obdo case, which was pre-Loper-Bright, and the Varian case, which was post-Loper-Bright, demonstrates that. So that, again, is sort of the point, like 20 years from now, we're going to notice that much has changed. I mean, maybe not. There's just a different playing field that we're dealing with.
Can I say on Varian, it sort of illustrates how extreme all this is. I mean, the facts of Varian they ended up, because of a glitch in the statute, for the same foreign tax they paid, they got both a credit and a deduction because of a glitch in the statute. And the Treasury tried to fix it with a regulation, and the court said, you just can't do that. And, it just shows, unless somehow the Treasury gets the authority to close glitches, people didn't have, every statute has glitches, especially because they're passed quickly. And if the Treasury can't close them with regulations, it's going to be a real problem for the system.
Bring back technical corrections bills.
Except they can't do that with reconciliation.
Sure.
Well, they can, they just don't
Right.
because
Well, I thought you couldn't.
They don't have revenue effect generally. If it's technically a technical correction with retroactive application, there should not be revenue and it shouldn't be eligible
And
for
it-
reconciliation, I think.
Right.
Yeah.
And it can't go through reconciliation. You need a standalone technical corrections bill, which has got to pass by a majority of the Senate
You
without
can't,
the
you can't do
exception.
tax bills with, yeah.
The problem is that when there is, a 51-49 vote on something,
Yeah.
The question is that the court's fault or is it Congress's fault?
Well, and my observation on this is that Treasury, and you can understand with like the TCJA regulations, that issue in Varian, like Treasury wants to make the TCJA work correctly. It was the highest domestic priority for the prior Trump administration. So regulations are going in and trying to fill the void here when Congress isn't doing technical corrections. And I think that has empowered Congress to say, well, we don't need to worry about our broken effective date here. It'll be fixed by a regulation, and the regulation is rendered invalid. So I think to some extent, the Treasury Department, like, I wouldn't call it overreaches, but goes in to do the job that Congress should be doing in fixing the broken statutes, and that empowers Congress not to fix broken statutes.
Well, this is sort of jumping ahead, but that doesn't really work. That's a very pro-taxpayer result because every statute both has pro-taxpayer glitches and anti-taxpayer glitches. The Treasury, like in TCJA, they tried to fix both, helping the taxpayers when the glitch really shouldn't have hurt them and vice versa. So all the anti-taxpayer regs fixing glitches are all going to be held invalid now. And the pro-taxpayer regs, which equally bad glitches, but nobody can challenge those as nobody has standing. So the taxpayers really get the best of both worlds. The anti-taxpayer glitches get rejected under Loper-Bright, and the regs that try to help taxpayers because of an anti-taxpayer glitch, those nobody has standing to challenge. So it's really a one-way street in favor of taxpayers. And I don't think anybody questions that, but that's just the bottom line.
Yeah, I would note the Memorial Herman case, which
Well,
is not
yeah.
squarely on point there, but that is a regulation where the taxpayer tried to say, here is a regulation that helps me, and the court said, well, under Loper-Bright, you don't get to rely on that regulation. I don't think that's the right
Yeah, I mean,
interpretation
they
of the
didn't.
statute.
The taxpayer
quite
should
so
have argued
explicitly.
estoppel. I mean, that just can't be that you can't rely on a regulation that's outstanding. They didn't argue, the taxpayer didn't argue estoppel when the government sort of ignored its own regulation and went after the taxpayer. That just can't, I'm sure a good litigator would be able to win that case.
Rauenhorst, I think, is the case we like to cite for that. But
Yeah.
I would also say that Fifth Circuit opinion is unclear on this point about the regulation. It didn't read the regulation the way the taxpayer read the regulation, so it didn't really decide it. And it also considered some language in the Internal Revenue Manual, and it noted there that it wasn't binding on the IRS, and it cited to the fact that the Internal Revenue has been understood as not being binding authority. So the fact that it made that nuanced point about the IRM, which we'd probably all agree,
Right.
suggests the court may see more nuance than just, oh, they're not bound by taxpayer favorable regulations because taxpayers can't rely on.
Right. It's a little odd that they cited Loper-Bright, and certainly the government didn't argue that their own regulation was invalid there. So
I will make the observation that tax aside, just in general, it seems like every other court opinion these days is citing Loper-Bright for something. Wading through all the citations to Loper Bright is an exercise in just frustration because they cite it for everything, whether it's whether really doing something with Loper Bright or not. So it's that sort of Supreme Court opinion, unfortunately. So trying to map what's going on with Loper Bright is a real challenge.
Well, and courts are citing it because litigants are citing it too.
Sure,
And I will
absolutely.
plead guilty to that as well. I win this case because C. Loper Bright.
Right, exactly.
It's also in every tax opinion at this point.
Sure.
I think often oversighted. Just one more observation on the potential impact of Loper Bright. I think this ought to be true. It doesn't mean it will be true. It's not just that there were glitches in the TCJA that then we looked to Treasury to fix for good tax administration. As Congress was passing the TCJA through the reconciliation process, where I have learned from my legislative friends, speed is a blessing. It's on purpose. The beat was out there for 6 weeks because they didn't want us to figure out it was an outbound provision and not an inbound provision. Legislative proposals are like fish in the kitchen and house guests. Like they don't do well when they hang out. So they try to pass this stuff really fast. Well, even despite that, in TCJA, some of these glitches were pointed out. They knew about the problem with 958B4 before they passed it. And they added a sentence in the legislative history to try to urge Treasury to fix it in regulations. That does not work now. That is, if there's a question about what is the implications of Loper Bright, that does not work. If Congress recognizes a glitch and in their reconciliation process and they've already got an estimate and they don't want to deal with the Byrd rule and blah, 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 and they realize a statute is broken and they pass it, they just chose to pass a broken statute that we're going to live with forevermore.
I think that's a little bit of a debatable point. It's mainly valid as a point because the courts are so much more textualist than they used to be. Yeah. If you get a purposivist panel or a purposivist judge at a lower court in a case that doesn't make it all the way up, you still might be able, depending on the delegations point we're going to talk about in a few minutes, you still, in theory, might be able to get such a reg through. But I agree with you
as the
that
accounting firm hack,
maybe
I'll tell you that when we write opinions, it's what we think is going to happen at the Supreme Court that matters.
I wouldn't want to do a will opinion on that myself.
Yeah, maybe you'll get a district judge to ignore the literal language of the statute, but that's a risky position for a district judge to take because there's a good chance they'll be reversed based on the literal language.
So we have arrived at our next polling question. and here I'd like to set it up with some tax exceptionalism, and then I'm sure I'll get beat back. Tax is incredibly complicated. You have a particular provision, it interacts with so many other provisions in the code. So in a world where we're going to have each court evaluate the best reading of a particular statutory provision, I am going to bet that we are going to end up with a bunch of inconsistent interpretations of what the best reading is. I can tell you in KPMG's Washington National Tax, we often have a bunch of different interpretations of what the best reading of a statutory provision is. Michael is nodding. We're usually on the same side. Not always. There will be splits among the courts. Regulations used to come along and resolve those ambiguities, and we recognized that the regulation, that was the rule we were all going to live by. So our polling question is it more important to have the absolute best reading of the statute through a long and arduous process of conflicting court decisions, or would consistent administration, maybe through some deference to regs when we find ambiguity, be better?
And to Michael's point, I'm not sure that A is an option, right? Because
it's not actually an option. This is the depressing portion of it.
Exactly, right. It's a hypothetical question.
But everybody likes it.
Everyone likes it, that's right.
I did lead the witness a bit.
Well, and it'll be interesting to see. I mean, it's also on a certain level, in terms of the effect of Loper Bright, it will ultimately be an empirical question. How often courts overturn tax regs, especially if those tax regs have gone through notice and comment, have been consistently applied, etc. Because remember, Loper Bright's counsel about courts finding the best reading of a statute using their independent judgment includes discussion of Skidmore factors like consistency and another factor that isn't in Skidmore itself but has come through in Skidmore jurisprudence is sort of the it's in thoroughness of the agency's consideration is in Skidmore itself, but also the formality of procedures that are used is in the Skidmore jurisprudence. One thing that we've seen post Loper Bright, not necessarily in tax cases, but elsewhere, they don't always cite Skidmore. They're starting to just cite Loper Bright rather than Skidmore, but courts talking about things like consistency or longevity or contemporaneity with Congress's adopting the statute, all these Skidmore factors as informing their decision about what is the best reading of the statute. So until we have a large enough collection of cases that we can reach empirical conclusions about what the court's doing, let's not get ahead of ourselves too much about saying that we're just ponying up for inconsistency and chaos in tax administration.
Let me give just a practical example of this, and just from the perspective of a regulator. Back in 2019 or 20, when I was at Chief Counsel, there was a split in the courts over this issue of supervisory approval of penalties. So the IRS, before they can assert a penalty, needs to have the agent get supervisory approval for it. There's a tax court decision and at least 2 circuit court decisions that take different views. And then chaos across the country, because in all the different circuits, to Michael's point, you got a potentially different answer. So how's the IRS supposed to administer penalty approval if you've got a tax court decision, potentially of nationwide jurisdiction, and then 2 circuit court? So the answer is, well, let's put a regulation out there. Let's just promulgate a regulation with one uniform. We'll pick what we think is the best answer and put a regulation out there. It may not be the best answer, but at least a reasonable interpretation. So that was one way that regulations could be used. And thinking under the perspective of Chevron deference, well, let's just put out a uniform rule there. And the courts would typically defer to that and say, even though we had decided this differently before, it's a reasonable interpretation of Chevron issues, and we don't need to worry about our prior decision, sort of Brand X type issue. But I don't know that that's an option anymore for the rule writers to go out there and just unify the law because there are 3 different interpretations of the statute.
I agree with you. Treasury is not going to be in the position to be able to resolve circuit splits.
Right.
I mean, I think to some extent, even the empirical issues, and it depends on just how clear the statute is. If the statute is truly ambiguous, truly 50-50, I think courts may well defer to Treasury. They have the expertise. But if it's 60-40 or 70-30, they may not care what Treasury does. They'll just say, this is the better reading, that's it.
Yeah.
And certainly, the cases I've been talking about is really, it's a glitch. It's almost, it's a Chevron problem even, except, people, Chevron, you get over that 100% hurdle and you can do whatever you want in the government. There's a lot of examples of that in TCJA. But now there's only one borderline and it's 50%. And, I think it's just that the whole atmosphere is different. I think there's much more that we focus on just following the real literal language.
Now, many modern statutes include an express delegation to Treasury under the particular provision and they can be very open-ended or very specific. So I think we're kind of ignoring an elephant in the room, and a ready solution to Congress's difficulty with writing good tax law is to delegate to Treasury to write rules, to fill in gaps, but also to adjust. Sometimes there's delegations that talk about adjusting a statute. I always find that language the most interesting. I do want to take a moment here to say Professor Hickman has written the most awesome 40-page, that's short, law review article. 40 pages is super short for a law review article.
For a law review article, it's not long.
I have the attention span of like a rabbit, and I read it. And I really and she organized the different delegations and talked explicitly about what does 7805 authority mean, and I found it incredibly helpful. So I'm going to ask Professor Hickman to talk about how she organizes her thoughts around delegation. I also, just as an aside, want to say, like practically in a footnote, you resolved something that had bothered me from my youngest lawyer days. When people would talk about interpretive versus legislative, and then they would talk about interpretive rules not being rule of law, like being legally enforceable, and I was like, what? And you just acknowledged that maybe that was true at one point, and then it drifted away, and the court never acknowledged that that is not where we stand anymore. I found it incredibly gratifying to read how you addressed it, and like sometimes it's not clear, but you were able to acknowledge head on, I can't reconcile this for you, reader. I'm just going to tell you how it is. It's not reconcilable.
Sometimes answers are found in history.
And that's probably how it got to be 40 pages, is being willing to admit that maybe something can't be reconciled.
Well, so, and this is where we are in the slides. I think when we think about the impact of Loper Bright, it is important to recognize indeed that Loper Bright doesn't just say all agency actions get reviewed for the court's assessment of the best reading of the statute. There are two key paragraphs in Loper Bright that a lot of us have really, who write about these things have really keyed in on, where the court talks about the best reading of the statute being one in which Congress has conferred policymaking discretion upon the agency. Typically, the language the court uses is they talk about where there's an express delegation from Congress of policymaking discretion. We've got hundreds of delegations in the Internal Revenue Code that task the Secretary and thus the IRS with adopting rules and regulations to fill one congressionally identified gap or another. The court gives some examples in the Loper Bright opinion itself. When Congress calls on an agency to give meaning to a particular term, to empower an agency to prescribe rules to fill up the details of a statute, or to regulate a subject to limits such as appropriate or reasonable or necessary that obviously give the agency some flexibility. The example on the slide is 704C1A. My personal favorite express authority delegation like that is Section 1502 in the Consolidated Return Regs. And in those instances, the court doesn't say use your independent judgment precisely. Instead, they describe a different role for the courts when you have that sort of express or specific delegation, where they say, the court's job instead is to make sure that the delegation comports with the Constitution, figure out the parameters of that delegation. But then so long as the agency is acting within the scope of constitutionally delegated authority to make policy choices, then the standard the courts are supposed to apply in reviewing the agency's actions is reasoned decision making, or in other words, State Farm, if that rings any bells to people in this audience. And that's a deferential standard. It's a much lower bar to have to satisfy for an agency. So the real question to me anyway, post Loper Bright, is how to draw those lines. It sounds a little bit Chevron-like in terms of, step one is the meaning of the statute clear. If it's not, then step two, is the agency's choice reasonable? Some people have looked at these two paragraphs in Loper Bright and have said that they mean that the court didn't really change anything. They've just changed the lingo that we're using without actually changing the operation of what the courts are being called upon to do. I don't think that that's quite right. I think the court meant to do something more than change the lingo in Loper Bright. And if you just think it's business as usual, you're missing the Loper Bright boat. But the real question then becomes, how do you decide which regulations fall into the independent judgment bucket and which ones fall into the reasoned decision-making or State Farm bucket? I do have a theory on this. Before I get to my theory, though, I know that Michael wanted to talk a little bit about the constitutionality question.
Oh, well, there's the question, like 7805 is a good example of a very general delegation of authority. It says the Secretary prescribe all needful rules and regulations for enforcement. So let's say there's a code section that doesn't have a very specific delegation, to take the extreme case. And many regs are just based on 7805 is the only authority to issue regs. And so far the standard for what's a constitutional delegation, and all through Loper Bright when they talk about delegations, they talk about constitutional delegations. And there's a Supreme Court case pending that will be decided soon that may put more light on that, the FCC case. But the current standard has to be an intelligible principle. And 7805, which says prescribe all needful rules and regulations for enforcement, it's hard to see how that, if there is a real standard of intelligible principle, that doesn't seem much of an intelligible principle. But but we should be knowing more in the next couple months by the end of the term, because the FCC case it's actually in a sense a tax case, because it gave the FCC the power to set the fees that carriers have to pay for the universal service. And some people are challenging whether that's an improper delegation of authority to the FCC, and certainly the challengers are claiming it's a tax case because the fee is like a tax, and they're claiming there's actually less power to delegate in the tax area because the Constitution specifically puts the taxing power in Congress. Now, there's prior Supreme Court cases say no, it's the same test, and the government is saying it's the same test, but still, it looks like the intelligible principle standard, sorry, may not be around too much longer, because several of the conservative justices in concurring opinions and dissents have said there should be a stricter test, and they finally got a case they granted cert on to decide the question. So in a few months, the intelligible principle standard may be obsolete, and it may be a stricter test, which will make it even harder for 7805 to stand up as a good authorization for regs. Now, still, the code is filled with other levels of specificity. I mean, 704C1A is a good one because, what that says is they have the power to, under regs, income, the rest of that section says under regs, income deduction and so on is allocated so as to take account of variation between basis and fair market value of contributed property. That's a very specific test. You have some differences between basis and value. How do you deal with that difference among the partners? I think you'd agree, that's a fairly specific test, and almost anything they do that's arguably within the scope should be okay. 7805 is the other extreme, which probably or may well fail the test. And I know your great article talks about all the different alternatives.
But just a quick footnote on the non-delegation. It's been since the 1930s, I think, that the Supreme Court has ruled on non-delegation. So if the FCC case overturns that on constitutional ground, it will be a very significant change in jurisprudence.
Yeah, I mean, the intelligible principle standard has been around since 1928 in the J.W. Hampton case. It's been the only statute that the Supreme Court has invalidated on non-delegation grounds in its entire history was the National Industrial Recovery Act and the Panama Refining and Schechter Poultry cases in 1935. And regarding 7805A, they haven't specifically ever looked at 7805A, but there was a similar general authority provision in a different statute, and honestly, I'm blanking which one, but there's a case from the early 1950s involving a general authority type grant like that the Supreme Court upheld the constitutionality of that language, at least in the context of that statute. I think it was actually an FCC case. Now, they could overturn intelligible principles in consumers research. You're right. They've made some moves. They talked about doing that, particularly in the Gundy case about 5 years ago. And there have been some noises since then. But they've also made some other, what I would label as sub-constitutional moves, like overturning Chevron in Loper Bright or expanding the role of the major questions doctrine, that suggests the possibility that they won't replace intelligible principles. But we'll have to wait and see.
Yeah, wait, let me say, I actually think they're going to uphold the statute in FCC because it has a very general standard, but there's also a lot of other things, and this is sort of the catch-all at the end.
No, that's right. I think actually, I suspect if they are going to overturn, if they're going to decide against the FCC and consumers research, my money's on, they've delegated an awful lot of authority to a private corporation.
Well, they actually.
I think it'll be the private non-delegation aspect.
Well, actually, I think they'll probably uphold the actual I'll get to why that point in a minute. But I think they'll uphold the actual text of the delegation, but maybe have a stricter standard because I think the actual delegation that meets is a very specific one. They also subdelegated to a private agency, but it really wasn't. When you read it, it wasn't really a delegation. The private group makes recommendations. And then the FCC had to approve it, or it may have been a negative option, but they still had to agree with it. Sure. And there's once or twice they didn't. So there's a good chance they'll say, well, it wasn't even a delegation. It was they kept the ultimate power themselves. But by the way, anything they say about delegations, the government brief actually talks about this, that on that context, that if you say, if there was a delegation there, the government said, I forget which party says that wouldn't be a good delegation because it's a delegation to a private party and that violates the appointments clause to the Constitution, that you're not allowed to delegate to a private party. And that would at least raise a question about PMD and anything else based on book income, because that's we're delegating to FASB effectively. So conceivably that case could decide some other broader questions rather than just delegation.
I will make one observation about the question at the end of this last slide. Can a delegation permit Treasury to write regulations contrary to what a court decides is the best meaning of the statute? If a statute actually has a best meaning, then I'm not sure that it represents a delegation of policymaking discretion. Usually when we think about delegations of policymaking discretion, we're talking about instances in which there is no obvious best meaning of the statute because Congress has delegated the authority to, in this case, Treasury, to fill in the gap. But that may be, your mileage can vary, I suppose, on what you think of as being when best meaning comes into effect, which gets back to this point about thinking about different kinds of delegations.
Yeah, I think it comes up because often the statute says under regulations, this shall happen. So there's some authority, but it's a question of exactly how far to change exactly what it says.
Sure, but that's part of defining the scope of the delegation, right?
Yeah.
There are delegations that actually refer to adjusting the statute, like 7874, I remember taking note, has a reference to adjusting the statute. And I think in other cases where I might have in mind that Treasury would have written regs that would be contrary to a decision is they would call it filling in details regs, but they lead to a different result. And I think that, and then your circuit split of Treasury writing a rule to a circuit split, and there's an under regulations.
Well, and there's a challenge to
carry out the purposes.
Right.
I'm sorry.
Right. Prevent the abuse of the statute, purposes of a statute with no legislative history. So who's supposed to know what the purposes are?
Yeah, 1275 says they can change the debt rules to carry out, specifically change what's already there to carry out the purposes. The consolidated return regs, 1502, after Treasury lost what's the case? They lost I forget the name of the case immediately.
Rite Aid?
They lost the Rite Aid case because even though there's a broad delegation, the Rite Aid case says, well, they can't override a specific code section. So Congress amended 1502 to say, yes, they can.
But then Congress resolved the question.
Which they promptly did.
Right.
Anyway, so Danielle wanted me to talk about, particularly this is relevant in the context of 7805, but to the extent that we're talking about when does an agency have discretion, when does Treasury have policymaking discretion, when does a regulation fall into the reasoned decision-making bucket as opposed to the best reading of the statute, independent judgment bucket under Loper-Bright. This is not, one of the things that's tricky about the Loper-Bright opinion is it's really clear, I think, that the Supreme Court is trying to move the line as to how you distinguish between when an agency has policymaking discretion and when the court is supposed to resolve statutory ambiguity relative to where that line was drawn under Chevron. Under Chevron, we said ambiguities are delegations. We rejected that in Loper-Bright. So now where do we draw the line between policymaking discretion or mere ambiguity that is left for the court to resolve? This is not laid out anywhere in the court's opinion itself, but to the extent that the court in Loper-Bright relies very heavily on pre-Chevron cases like Batterton versus Francis. And if you look at the examples of express delegations that the court offers, it offers a whole bunch of them in a few footnotes for examples of where policymaking discretion has been delegated by Congress. One way of thinking about this could be the following. So think about the tax code. We've got specific authority delegations where Congress explicitly says, Treasury Secretary, go adopt regulations to do X, Y, or Z, like, for example, 1502. Then we've got 7805, general authority. In some statutes and some academic commentary, similar provisions to 7805A contained in other statutes are sometimes referred to as housekeeping delegations. You know, regardless, you know, this is not, 7805A is not unique to the tax code. There are lots of statutes that have that sort of a provision that's set off from all the substance. You know, 7805A is in the administrative provisions of the code. Just under, you know, it's just granting this broad authority to adopt rules and regulations as are needful for the
It also
enforcement.
doesn't say to carry out the purposes.
Right.
It says needful rules and regulations
For enforcement. You know, what does that mean if you're thinking about it textually? But just as importantly, it's set off from any particular substantive provision because we've got a third kind of delegation in the tax code, what I would label as hybrid delegations, that use the language of general authority or something like it, but they're contained, say, at the very end, for example, of a substantive code provision. A couple of, you know, my favorite examples here, 382M or 956, if I can read my own handwriting, E. You know, these are provisions, you've got a substantive provision of the code that contains a fair amount of detail, and then you get to the very bottom, and the last subsection says, oh, and by the way, the secretary shall have all needful authority to adopt rules and regulations as needed to fulfill the purposes of this section or for the enforcement of this section. Sometimes they'll include a little additional language like including, and we'll offer a couple of examples, but it's very broad language that resembles general authority but is in a substantive provision, unlike 7805A. That's what I would label a hybrid delegation. In thinking about these different kinds of delegations and thinking about Loper-Bright's efforts at line drawing and going back and looking at some of the history of the non-delegation doctrine, thinking about pre-Chevron deference history and so forth, a co-author and I have laid out, you know, an argument where we say, okay, fine, specific authority delegations, and we think hybrid delegations as well, represent the kinds of express delegations of rulemaking power where that reasoned decision-making standard ought to be the one that applies. But under 7805 general authority, we suggest it's not that, we continue to maintain that given sort of the history and trajectory of the Internal Revenue Code as well as other cases, that Treasury ought to have the authority to adopt legally binding rules and regulations interpreting the code under 7805, but the scope of 7805 may be limited to the kind of regulations that represent the best reading of the statute as obtained through the application of traditional tools of statutory interpretation. In other words, the kind of interpretations that a court could get to on its own, Treasury may be able to adopt in rules and regulations and to try to provide some consistency and some uniformity, but those rules would get reviewed under the independent judgment standard. To us, that's a way of thinking about different types of statutory delegations in order to fit within the Loper-Bright framework and move the line between policy making and mere interpretation in a manner that we think is consistent with what the court is talking about, even if the court hasn't said it explicitly. You can find the full article. You know, we think it helps to reconcile Loper-Bright with the court's non-delegation jurisprudence and its major questions doctrine jurisprudence. You can find the article on SSRN. It's forthcoming in the NYU Law Review, and I'm presenting it in longer form tomorrow at the Administrative Law Symposium that the Law Review here is holding in this building.
So come back tomorrow.
Indeed.
I think there's a real note for Congress in there because I think Congress can solve its problem of issuing rush statutory rules in reconciliation and not understanding exactly what they're doing with some hybrid delegations. I think you've really pumped the brakes there on reading too much into 7805, and which may very well be right, because as I have reread it, that necessary for enforcement I take note that is very different than carry out the purposes. The one place I've wondered, and this is my tax exceptionalism again, is there are places where, and these are probably older statutory provisions that don't include their own delegation, but where we have an unbelievably general provision out there that we have to apply to an incredibly detailed world. And it would not be administrable, enforceable for the IRS to just leave that bare bones statute out there. That enforcement requires some filling in the details regs. And I wonder if 7805 gives the IRS some berth in that space.
I'm skeptical for the simple reason that it doesn't identify those spaces as instances in which Congress is calling for regulatory activity, but it's early days yet. We don't necessarily know how the Supreme Court is going to address those kinds of situations. And I also don't know, I mean, I genuinely just have no clue whether we're talking about 500 regulations or 5 as we look across the code and find those instances. It's a lot less administrable for lower courts than the sort of categorical definitions I'm describing. Now, whether that holds sway or not, we'll again have to wait and see.
Also, the more broadly you interpret 7805, the more likely it is that it's not an intelligible principle and it's unconstitutional.
Well, and the more broadly you interpret it, the less it looks like the Supreme Court changed anything with Loper Bright.
Yeah.
And I just don't think it could possibly be the right answer that the Supreme Court went to all the trouble to overturn Chevron and put Loper Bright in place if they didn't mean to change something.
Well, and we're looking at this through the tax prism too. I mean, one interesting point this brings up is that Congress since 1984 has been writing tax legislation against the backdrop of Chevron and 7805, right?
Sure, but they've been doing the same thing with lots of other agencies
No,
and lots
understood.
of other staff.
I thought tax was special.
I know,
No.
right. But now
Tax is special, just not in that way.
and there has been a trend even pre-Loper Bright for Congress to add more detail and more grants of specific reg authority, not detail, grants of reg authority in specific statutes throughout
Oh,
TCJA.
absolutely. Well, not just the TCJA. If you go back and you look at Dodd-Frank or the Affordable Care Act or lots of contemporary legislation, you see many, many more instances of specific authority delegations, specific authority rulemaking grants than maybe you did back in the 1930s, although there are a fair number in the 1930s.
Yeah, and some of that may be kind of Congress looking around the corner. Chevron has been sort of questioned for years now in the Supreme Court. There's been a trend toward Loper Bright. It didn't just come up out of the blue. So
No,
Congress and
that's
TCJ, I think, was certainly looking to, will Chevron be there? Is there going to be a different standard? So there's
Although
a
I
lot more
think
detail.
Dodd-Frank and the Affordable Care Act were both enacted before the big push.
Yeah. But it will be interesting to see if there's a change in, statutory drafting that comes about as well. And I know from the kind of regulator's perspective, Treasury and the IRS always want to see a more specific grant of authority and take a lot more comfort in having that in a particular statute.
My advice to any legislation drafter would be pay attention to your delegation language.
Yeah.
Yes, please.
And then there's sometimes, looking at some statutes where you made the point earlier that oftentimes you have a statute where at the very end, subsection E says grant of authority for the statute. But you also see grants within a subsection.
Sure.
So,
Absolutely. There's the language of general authority all throughout the code, just in these little sub-provisions. But when they're in substantive provisions, Justice Barrett in particular likes to talk about reading text in context. And, when you've got general authority language either at the end or in the middle of some subsection in a larger substantive section, it only makes sense to read that language in the context of the section or subsection of which it's a part. That's different from 7805, which is off by itself.
But if you've got, section 101B3 has a grant of reg authority, but then, 101 itself doesn't, and that punts you for every other interpretive question under that statute to 7805? It's sort of a weird to your point about
again,
statutory construction.
it depends on the language of the hybrid delegation, right?
Yeah.
And I will also make the observation that, for example, this is where Justice Gorsuch and Justice Barrett differ, I think. Justice Gorsuch likes to look at the particular phrase or, sub-provision that is the gravamen of the case, if you will, and to look at that language in isolation and to evaluate it for, on non-delegation grounds by itself, whereas, at least thus far, Justice Kagan, Justice Jackson, Justice Sotomayor, but I would argue also Justice Barrett, and potentially we'll have to wait and see with respect to some of the other justices. They're more willing to look at text in context. So given your example, I would say, if you've got hybrid delegation language in subsection E of a particular substantive section, and it's referring to the entire section, well, you've got lots of detail above that in that same section, and it seems to me to make sense to read that subdelegation or that hybrid delegation language in the context of that substantive provision. Whereas with 7805, it's just a lot harder because the only context you have there is the entirety of Title 26.
Okay, I'm gonna have to move us along.
Yeah.
I will do a thumbs up or thumbs down on section 482 as an explicit delegation. Yeah?
Mike was thumbs down.
I don't know. I don't.
You
Jack
don't care?
Townsend agrees with me.
I don't think it matters in the end, but
I've been arguing with Jack Townsend about this
I'm
for years.
semi-retired, so the
Okay,
rest
so
of us care.
now the question, so we've got all these executive orders, and we just got an update to one of them today. There was the February 19th executive order that said, hey, every agency head, I want you to review all of your rules and regulations, and in 60 days, give me a report of any of them that aren't constitutional or don't reflect the best reading of the statute.
60
Today-
days. 60 days. How much longer do we have in that 60 days? About a
February
week?
19th,
About
March
2 weeks? About a
19th,
week?
April 19th.
Yeah,
Yeah, I'm sure they're pumping it
it's
out.
coming up.
Yeah, exactly.
But then have a long list, thousands of rigs. There's a long list will be coming out presumably.
Yeah, I bet there are zero.
Well, the other
Or
thing,
maybe they'll put out a couple just for purposes
Well,
of.
they just put out the notice 2025-19
Yeah, yeah.
soliciting input. on
yeah,
this.
Friday
Well,
they asked Friday they asked for comments from the public, giving them some period to say what rigs should go in the guidance plan for next year. So they're not apparently ready to put something out. But then, as
Well-
you were saying, this morning they ordered the OMB ordered the whole government to come out with a list promptly and to immediately withdraw. Don't worry about the Administrative Procedure Act. Just immediately withdraw all the ones that don't comply with Loper Bright, based
In
on
your
the
judgment.
based on the APA exception for
Which is a
for
very
reasonable
aggressive.
cause. Yeah.
It's a very aggressive reading of the APA that I'm
Yeah.
skeptical.
But
will
who's got
survive
standing to
judicial
challenge
review.
that?
In the tax context, it's hard. Although I was talking with both you and Danielle earlier about how it does make me wonder. This is less probably useful to garden variety tax attorneys dealing with taxpayer compliance, but we've got these different regulations in the tax context dealing with tax expenditures and carbon sequestration credits and all kinds of things like that. And I wonder if we might have a broader standard for standing taxpayer standing in those contexts.
Well, what I'd like to know is, in this list of all the rigs that don't comply with Loper Bright, is they're not the best reading of the statute. Are these just going to be the anti-taxpayer rules or also the pro-taxpayer rules? Like, let's say check the box. Are they to withdraw the check the box regs? There's absolutely no basis in the statute for that. I have a whole list.
Couldn't you read the list? We're all still very busy representing taxpayers. If you wouldn't mind,
I'm not sure I'm going to find a client.
Or am I
you just-
teaching students?
could you read the
I
list?
have a few highlights. The 1031 rules for qualified intermediaries for like-kind exchanges. There's no basic, that clearly violates all kinds of economic substance and step transaction. There's no substance to qualified intermediaries in the code. The 355E, the super safe harbor for spin-off transactions, where there's a presumption there is a plan, and notwithstanding that, the regs say there's a per se safe harbor that there isn't a plan, contrary to the presumption. Qualified reopenings of debt that everybody relies on to keep fungibility of when you have a new debt issuance. Under the code, it's clear it's a new issuance. I mean, there's all sorts of things like that. There's also the basic things that people rely on every day, that if they're going to take this seriously, they're gone.
When I was in government, we used to say we could do anything by election, because who would challenge it? It's always every election is taxpayer favorable, but I'm not sure that was the best reading of the statute, that there were these alternatives.
So is every opinion now going to say, especially if the government isn't bound by their regulations based on
Well,
that?
but on the other hand, I have been hearing for years from people at Treasury and the IRS that they lack discretion because all they do with their regulations is implement the best reading of the statute. I remain skeptical that agencies are going to sweepingly take their most significant regulations and cop to the idea that they don't represent the best reading of the statute. I can imagine them behaving strategically and identifying some regulations that they're just as happy to get rid of as perhaps this regulation isn't based on the best reading of the statute. But I would imagine them being strategic and selective in that way, rather than truly going through an exercise of which regulations do we want to admit are not based on the best reading of the statute, in some kind of principled way that really reflects what a neutral observer would agree with.
Well, and there could be very significant knock-on consequences if there were to be such a list.
Yeah.
Because I think oftentimes Treasury doesn't appreciate the extent to which regulations have been relied upon for all sorts of purposes.
Right.
And you could upset a lot of apple carts if you put a list out there of regulations that Treasury thought was invalid.
Right. Well, and for that matter, I will come back and say, remember, the best reading of the statute, according to Loper-Bright, can be influenced by those factors that give the agency the power to persuade if lacking the power to control, including things like consistency, longevity, contemporaneity with the adoption of the statute, formality of the procedures that the agency used, the thoroughness evident in the agency's consideration of the question, and so on and so forth. And so if best reading is leavened by Skidmore factors, then you're not necessarily talking about best reading, in absolute terms. You're talking about best reading in relative terms in the context of the regulation in question.
The one I forgot to mention was carried interest. There's actually no basis for saying that a partnership interest granted for services is not ordinary income based on the value under Section 83. And that's not tied into anything
We're
else.
going to
It's
get
just
run
a
out of
separate-
town.
So that's the end of carried interest.
Those are fighting words. We have our last polling question, and that is get
Beep,
out your
boop,
magic
beep
8
for the
ball.
win.
Beep, boop, beep. Is that because we're over time? Or your chatbot 9000 broke?
I think we broke the chatbot 9000.
Had minimal impact on tax legislation, tax collection.
I will say this, I don't know about tax collections, but I guarantee you some administrative law scholar or political scientist will be doing empirical studies of this stuff before 2035.
Looking forward to it. I hope it comes out in a 40-page or less law review article.
As opposed to an 80-page one?
That's what I thought was the typical length. That's why I was so relieved.
Oh, I got plenty of those too.
I think this is when we're supposed to get off the stage. I've been not making eye contact with you for some time.
We're the last panel. We're the last panel.
We're the last. Okay. We're the last panel, so we don't have to go.
And Kristen's here all day tomorrow, too. So it's a presentation.
Well, thank you all, audience, for your
Thanks, everyone.
attention.
Panelists, a great afternoon.